Hey guys, welcome to this video. My name is John Watts and we're going to cover a new case decision. It's actually not new, but new for us on this video. And this is the Smith versus Nationwide Collection Agencies, Inc., doing business as Money Recovery Nationwide. It's February 19, 2019. And the reason I want us to look at this is it demonstrates a couple things. One, about the FDCPA and specifically Section E8, so 1692 E8, that talks about if you notify a collector or if the collector just knows that you dispute an account, then it has to mark your account on your credit report as being in dispute. Now, most courts say they don't have to do that immediately, but it's as soon as they next update the reporting to the credit bureaus, which is usually once or twice a month. And it also will demonstrate the standard for summary judgment. In other words, what is a genuine issue of material fact that's in dispute? So let's get into this. And this was brought under the FDCPA, a Michigan law. That's not really important. What we are looking at here is the facts now. So plaintiff alleges she sent a letter to the defendant disputing 3 debts, but defendant failed to report 2 of those debts as disputed as required by the FDCPA. So plaintiff says, hey, I sent the defendant a letter in April 2017 disputing 3 accounts. So it's 445, 446, 374. And the court notes that it is significant plaintiff does not attest in an affidavit or a verified complaint that she sent the letter. And the copy of the letter itself, which was attached as an exhibit to plaintiff's motion for summary judgment, does not contain any indication as to whether or when the letter was mailed. In other words, it's just a letter. So let's take a step back. On summary judgment, whoever's moving for summary judgment is saying, Judge, you don't need to have a trial. Okay, the facts aren't in dispute. The law is clear. I win. And so you attach evidence to that. And then the court says, well, look, this is actually, it was sent to the wrong address is what the defendant says. And so remember our facts here that, let me just do this here. In April, the letter was supposedly sent. June 19, July 17, plaintiff ran her own credit reports, discovered and marked only 1 of the 3 accounts as disputed. And the defendant says, well, look, there's no evidence supporting this unsworn allegation that plaintiff sent the dispute letter attached to the motion. And then the defendant says, even if you did send it, we didn't get it. So here's a couple things we can deduce from this. One is the letter was not sent by certified mail, or that would be pretty prominent. It's like, hey, they signed for it. Another thing is you can send one letter and dispute multiple accounts. Actually, the dispute letters that we suggest people send, they just say, I dispute owing any debt with your company. That way, what if you write the account number wrong? What if they have an account you don't know about? Hey, any covers any and all, okay? And what's puzzling to me is why the plaintiff did not offer an affidavit and say, I sent the letter. Now, having read some other decisions involving this law firm, I think at least it appears that from time to time, the lawyers send out the letter on behalf of the client. The client doesn't actually send out the letter or sign the letter. And that may be why the plaintiff can't honestly testify, yes, I swear under oath that I sent that letter, because maybe the plaintiff did not actually send the letter. So here's what we have that is in agreement. And then we'll talk about what's in dispute. They agree the plaintiff is a consumer under the FDCPA, the defendant's a debt collector, and that the disputed debt is a debt. So the elements of a cause of action under the Fair Debt Collection Practices Act is consumer debt, dealing with the debt collector, then they violate the law. So the parties dispute whether the defendant violated the statute by failing to report 2 of the 3 debts as disputed. So here's the law that we're talking about. This 1692 E8. Communicating or threatening to communicate any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. So the court points out for us that under the FDCPA, defendant has an obligation to report as disputed any accounts which it knew or should have known plaintiff disputed. And the court points out, well, there's no definition in the FDCPA about what disputed mean, but courts have interpreted that term in accordance with its ordinary meaning, holding there's no specific language or form for disputing a debt. So there's no magic formula you have to use. If you say, I dispute the debt, if you say, I deny the debt, if you say, that's incorrect what you have on here, I mean, all of that would be sort of obvious to a collector that, hey, you're disputing this debt. And we'll skip over that part, go to the analysis. And judge just tells us right up front here. The record reveals there's a genuine issue of material fact, namely whether defendant received plaintiff's dispute letter. I'll be honest, I'm a little surprised. I think this judge is being generous to the consumer here, because without the consumer putting forth actual evidence that the letter was sent, I think a lot of judges would just have thrown this case out. But this judge didn't do that, so that's good for the consumer. The only indication plaintiff sent a dispute letter is an unsigned copy. She has not provided any affidavit or verified complaint averring she sent the letter, nor has she provided any documentary evidence that she placed the letter in the mail, such as a copy of a receipt for postage. And the plaintiff says, well, look, the defendant did mark one of those accounts as disputed, so it must have received the dispute letter. It's a good argument. It's the only argument that you can really make here. The judge said, but that inference is unjustified. There are many ways in which a consumer can notify a debt collector the consumer is disputing the debt. And this is really important, and it's something that, we may not just pick up on when we first read Section E8. But it says, indeed, the knows or should know standard, Section 1692E8, requires no notification by the consumer. So you don't even have to notify the debt collector. Instead, depends solely on the debt collector's knowledge. So we're saying, what's in the debt collector's head? Knowledge that a debt is disputed regardless of how that knowledge is acquired. And then the court says, the fact that defendant marked one account as disputed cannot be taken as evidence it received plaintiff's April 21 letter without some degree of speculation. As this is plaintiff's motion, the court cannot speculate as to issues of fact that favor plaintiff's position over defendant. So what's called the non-moving party. So here we have the plaintiff is moving for summary judgment. Well, what about the defendant over here? They're not the moving party. So if there are questions or inferences, we rule in favor of the defendant, the non-moving party. Now, normally it's the defendant moving for summary judgment, and we say, look, we resolve all inferences or disputes in favor of the plaintiff, the non-moving party. So the court's just saying, look, that's an inference, but I can't say just as a matter of law that it's absolutely established that they got the letter. So let's look here at oral argument here. Now, I don't know what exactly was put in the record. Again, if this was only brought out at oral argument, not in the record, most judges would say, well, I'm not going to consider that. But anyway, the defendant says it received an e-Oscar report January 26, 2017 that a credit reporting agency, so that'd be like Equifax, Experian, TransUnion, had marked the account ending 446 as disputed. And this is where the consumer had disputed directly to the credit reporting agency. And then in a supplemental brief, the defendant said the report it received showed the plaintiff had disputed account 446 directly with credit reporting agency TransUnion on the ground that had been included in previous bankruptcy. And so the defendant says, well, once I got that notification, I just reported to all three bureaus that it was in dispute. And the court says, well, this is a plausible explanation for how one account out of three was noted as being in dispute without the defendant ever receiving plaintiff's dispute letter. So again, summary judgment is not for the judge to say who's right, who's wrong on the facts, but just to say, is there enough that this should have to go to the jury? And then a jury decides this issue. And so taking all reasonable inferences in defendant's favor because they were not the moving party, The fact that the copy of the letter has the incorrect business address for defendant, along with lack of evidence the letter in the record was actually mailed, raises an issue of fact. And it says, if I can make the highlighter work here. All right, let's try it this way. The issue of fact is genuine and material because if defendant did not receive plaintiff's dispute letter and did not have notice of the dispute by some other means, and it's talking about for those other two accounts, it did not violate Section 1692E8. Statute requires defendant report a debt as disputed if it knew or should have known. Without receiving notice of dispute, it could not have known disputed. Therefore, summary judgment is not appropriate. And so I think the follow-up to this, I think I saw a subsequent opinion that the parties have settled the case, and so it ultimately didn't go to trial. But I wanted you to see this for a couple reasons. One, just again to explain how that Section 1692E8 works, but also to see we have to have the evidentiary support. So if we're saying the debt collector did something wrong because they didn't get our letter, well, it sure is nice if we can prove that at least we mailed the letter. But even if we could prove, so let's imagine she offered an affidavit. I put it in the mail, I put it in the mailbox, it got mailed. Well, when the defendant says, I didn't get it, well, that's a question of fact. So sometimes it's called the mailbox rule. So if I put something in the mailbox, properly addressed, postage put on there, we can presume it gets to where it's supposed to go if I didn't get it back. But if the person that's supposed to receive it says, hey, I didn't get it, well, a jury's got to decide that. So we've had this in mortgage cases where a mortgage company says, hey, look, I mailed this to you. Okay, you mailed it to me, but the fact that I didn't get it at least raises a question of fact about whether or not you, the mortgage company, actually mailed it. So I hope you enjoyed this little case review, and if you have any of these that you'd like for me to cover, just copy and paste the Google Scholar link. So I try to pull these from Google Scholar so that anybody can look at these. I mean, we have, services where, subscription type services. But if you find a case, just copy and paste the link and put that in a comment, and I'll do my best to cover that. So thanks for watching us, and I'll catch you in the next one. Bye-bye.